It amplifies the magnitude of the occasion we are here to witness. I am Megha S. Iradi, Assistant Professor, GK Law College, Hubballi, your host for the event. And I extend a heartwarming welcome to each and every one of you to the special lecture and interactive session on career in judiciary. To invoke the blessings of Almighty and to set a harmonious tone, we will begin with an invocation song. I now invite Mr. Ganesh DS to lead us in prayer.
जय गणेश जय गणेश जय गणेश पाहि मां जय गणेश जय गणेश जय गणेश रक्ष मां जय गणेश जय गणेश जय गणेश पाहि मां जय गणेश जय गणेश जय गणेश रक्ष मां जय गणेश जय गणेश जय गणेश पाहि मां जय गणेश गणेश जय गणेश रक्ष मां मुदाकरात् मोदकं सदा विमुक्तिसाधकं कलाधरावतंसकं विलासि लोकरक्षकम् अनायकैकनायकं विनाशिते बदैत्यकं न शाशुभाशुनाशकं नमामि तं विनायकं नमामि तं विनायकं न तेथरातिभीकरं नवोदितार्कभास्वरं नमत्सुरारि निर्झरं नतादिकापुदुद्धरं सुरेश्वरं निधीश्वरं गजेश्वरं गणेश्वरं महेश्वरं तमाश्रये परात्परं निरान्तरं गणेश जय गणेश जय गणेश पाहि मां जय गणेश जय गणेश जय गणेश रक्ष मां समस्तलोकशङ्करं निरस्तदैत्यकुञ्जरं गरेतरोधरं वरं वरे भवक्त्रमक्षरं कृपाकरं क्षमाकरं मुदाकरं यशस्करं मनस्करं नमस्कृतां मनस्करोमि भास्वरं जय गणेश जय गणेश जय गणेश पाहि मां जय गणेश जय गणेश जय गणेश रक्ष मां जय गणेश जय गणेश जय गणेश पाहि मां जय गणेश जय गणेश जय गणेश रक्ष मां जय गणेश रक्ष मां जय गणेश रक्ष मां जय गणेश रक्ष मां। धन्यवाद।
Thank you, Mr. Ganesh DS, for the melodious rendition. Music truly has the power to elevate our spirits. Moving forward, I would like to extend a warm welcome to our esteemed guest. As it is in Indian culture, Atithi Devo Bhava, meaning the guest. I now invite Professor Dr. J.M. Mallikarjunaya, Dean, Faculty of Law, K.L.E Technological University, Hubballi, Principal, K.L.E Law College, Bengaluru, to render prefatory address and formally welcome our guest and present them with flowers. Please, sir.
At the outset, very happy to see the overwhelming response for this special lecture. May I request all students to take the seats, and if the seats are not there, you can all be seated comfortably on the stairs. Please take the seats. Honorable dignitaries, Anand of the dais, and invitees. Today is an auspicious day at K.L.E Society's GK Law College, Hubballi. As we assembled here for a special lecture and an interactive session on a career in judiciary, it was at the guidance and motivation of His Lordship, Honorable Mr. Justice Abhay Srinivas Oka. During the academic year 22-23, K.L.E Society's Law College, Bengaluru, in association with Samutkarsha Trust, conducted several special lectures and training sessions across the state on career opportunities in judicial services. Through these sessions, the judges and the senior advocates inspired the budding lawyers in law schools and the young advocates at the district and taluka bars. I fondly recall the culmination program of this attempt resulting in the National Colloquium on Judicial Services, Opportunities and Challenges, held on 20th August 2022, again at K.L.E Society's Law College, Bengaluru. His Lordship, Justice Oak, presided over the inaugural program and inspired the young lawyers towards a career in judiciary. In line with our commitment to training the young lawyers for judicial exams, when we organized at K.L.E Law College, Bengaluru, an intensive one-week training program called Gnanada Soha for the candidates facing judicial exams mains, His Lordship again came online and addressed our aspirants on 4th October 2023. This actually led me to realize His Lordship's deep concern and conviction in attracting young and able minds to accept judicial services as their career option, leading to an intellectually powerful judiciary. My Lord, we at K.L.E Society, through our 6 law colleges, have been making our sincere effort in that direction. And annually, about 15 to 20 of our graduates have been taking up judicial services as their career option across the country. With your motivation and blessings, I'm sure we will continue to improve our record in this regard. A lot more of the students arriving from over 25 law colleges of this North Karnataka region have gathered here today to hear from and interact with your Lordship. I'm sure they're all waiting to listen to your words and be inspired. The legal fraternity remains grateful for this noble saga you have begun, my Lord. Your very presence here today shows your concern for the cause. Without much ado, ladies and gentlemen, let me take this opportunity to extend a very warm welcome to His Lordship, Honorable Mr. Justice Abhay Srinivas Oka, Judge, Supreme Court of India. A very hearty welcome to you, my Lord. May I now request my colleague, Dr. Shanda G. Patil, to come on the dais and present a sapling as a token of welcome to His Lordship. Thank you, sir. On this momentous occasion, we have the fortune of hosting His Lordship, Honorable Mr. Justice Siddhappa Sunil Dutt Yadov, Judge, High Court of Karnataka. A very hearty welcome to you, sir. And I request Dr. S.M. Hullur, Assistant Professor, to present a sapling and welcome His Lordship. Thank you, sir. We are all delighted to have the presence of His Lordship, Honorable Mr. Justice Vedvasachar Sri Shananda, Judge, High Court of Karnataka. A very warm welcome to you, sir. I request Dr. Bahubali Kurkure, Physical Director of G.K. Law College, to present a sapling and welcome His Lordship. Thank you, sir. A friend, philosopher, and guide of K.L.E Society's law colleges, Mr. Jayanand Munwalli, a member of the Board of Management and the executive body for law colleges of K.L.E Society, has always been a source of inspiration for all of us. Sir, a very hearty welcome to you. And I request Mrs. Preeti Kasturi, Assistant Professor of G.K. Law College, to present a sapling and welcome our beloved leader. Thank you, sir. A dear friend and the principal of K.L.E Society's G.K. Law College, Dr. Daneshwar, a very hearty welcome to you. And I request Ms. Megha Reddy, Assistant Professor, to present a sapling and welcome her principal. I take this opportunity to extend a very hearty welcome to Honorable Justice Mrs. Uma Madam and Honorable Mr. Justice Adiga Sir and Honorable Mr. Justice Vijay Kumar Patil, who are in the audience. Other distinguished judges in the audience, members of the bar, members of the Board of Management K.L.E Society, dear students arriving from different colleges of this region, my dear colleagues in the academia, invitees, and last but not the least, most respected members of the media, a very hearty welcome to all of you. Welcome all. Thank you.
I also welcome Professor Dr. J.M. Mallikarjunaya, Dean, Faculty of Law, K.L.E Technological University, Hubballi, Principal, K.L.E Law College, Bengaluru, to this event. I request Naveen Sir to present a bouquet as a token of love and respect. We are fortunate to have with us today distinguished guests who are noted personalities. Each one of them bring invaluable expertise and insights that will indeed bring us fruitful and enriching experience. I invite S.M. Hullur, Assistant Professor, G.K. Law College, Hubballi, to introduce the guests.
Good morning, one and all. Dignitaries on the dais and off the dais. It gives me an immense pleasure to introduce the chief guest of today's program, Honorable Mr. Justice Abhay Srinivas Oak, Judge, Supreme Court of India, New Delhi. Sir was born on 25th May 1960, pursued his BSc and LLM at the University of Bombay, commenced his legal career by enrolling as an advocate on 28th June 1983, practicing initially in the Thane District Court under the guidance of his father, Srinivas Oak. Then in the year 1985-86, Sir joined the chamber of Sri V.P. Tipnis, a former judge of the Bombay High Court and former Lokayukta. Sir elevated as additional judge of the Bombay High Court on 29th August 2003, appointed as a permanent judge on 12th November 2005. Sir took oath as the Chief Justice of High Court of Karnataka on 10th May 2019 and took oath as the Judge of Supreme Court of India on 31st August 2021. It marks a significant milestone in his illustrious career. Sir has given significant judgments in the areas of civil matters, constitutional matters, and service matters. Notable judgments are Vinod Kumar versus Amrit Pal in the year 2021, Vasudha Sethi versus Kiran Bhaskar in the year 2021, and Debanand Tharmoli versus Kokomoni Takarki in the year 2022. Friends, with these few words, I once again welcome Honorable Mr. Justice Abhay Srinivas Oak, Judge, Supreme Court of India, New Delhi. Welcome to you, sir. Dear students, it gives me a great pleasure to introduce the guest of honor of today's program, Honorable Mr. Justice Siddhappa Sunil Dutt, Judge, High Court of Karnataka, Bengaluru. Sir was born on 3rd August 1972, a 1996 graduate of National Law School of India University, Bengaluru. As an advocate, Sir conducted many matters involving environmental issues and lake preservation on pro bono basis. His concern towards the preservation of lakes helped saving many lakes in and around Bengaluru. Sir has played a major role in preservation of Kappatagudda at Gadag district. Sir, in many matters, has given detailed guidelines for speedy conclusion of investigation in criminal cases and observed that disputes between the government bodies cannot be dragged before the constitutional matters. With these few words, I once again welcome Siddhappa sir to this kind of a program. Welcome to you, sir. Dear students, it gives me a great pleasure to introduce another guest of honor of today's function, Honorable Mr. Justice V. Sreshananda sir. Sir was born on 29th March 1966. Sir pursued his commerce degree from H.L. College of Commerce, Ahmedabad, and obtained LLB degree from Sir L.A. Shah Law College, Ahmedabad in the year 1988. Later, master's degree from University School of Law, Ahmedabad. Sir was appointed as additional judge of High Court of Karnataka and then taken oath on 4th May 2020 and permanent judge on 2021. Sir's father, Sri Veda Vyasachar, is one of the leading lawyer of Karnataka, known for his command over civil laws. Sir, heartily welcome to you to this kind of a special lecture and interactive session. Welcome to you, sir. Friends and dear students, it gives me a great pleasure to introduce the president of today's function, the director of K.L.E Society, Sri Jayanand M. Munwali, sir. Sir Jayanand M. Munwali was born on 6th November 1965, hailing from the Munwali family, known for its cotton trade business. His father, Sri Mahadevappa Munwali, was a director and a dynamic chairman of K.L.E Society. In his memory, the K.L.E Society established a Mahadevappa Munwali school in Gokak. Currently, Sri Jayanand M. Munwali serves as the director of the K.L.E Society and as the vice president of the Gokak Urban Cooperative Credit Bank. Sir has established a well-equipped hospital under the banner of K.L.E for the benefit of the people in Gokak and its surrounding rural areas people. Sri Munwali sir, a great admirer of education, has played a pivotal role in establishment of quality educational institutions such as K.L.E Society's ITI College, PUC, BCA, and nursing colleges in Gokak, which are known for providing excellent education. In addition to this, he actively engages in social service through initiatives like free meal distribution, that is Annadasoha, and organizing health checkup camps for the benefit of the rural people at Gokak. He also encourages talented students, ensuring that the facilities provided by the K.L.E Society are accessible to the common people. His contributions in this regard are truly commendable. Sir Jayanand M. Munwali is known for his humble personality and eloquence. Drawing from his vast experiences gained from both national and international exposure, he has significantly contributed to the field of education. It is our privilege to have such a remarkable leader shaping this sector. Sir, welcome to you to this kind of a special lecture program. Dear students, I want to take this kind of an opportunity to introduce another personality, that is the J.M. Mallikarjunaya sir, a principal of K.L.E Law College, Bengaluru. I also welcome to you, sir. So we have got our beloved principal, Dr. Gnaneshwar P. Chauri. On behalf of all students and faculty members, I welcome all dignitary to this kind of a special lecture program. Welcome to you all. Once again, I welcome all press and media persons, dear students who are coming from different law colleges and other institutions of North Karnataka. Welcome to one and all. Thank you.
In the words of Aristotle, the roots of education are bitter, but the fruit is sweet. Now it's time to hear from someone who has been a beacon of knowledge and a source of inspiration. Our chief guest for today, Honorable Mr. Justice Abhay Srinivas Oak, Judge, Supreme Court of India, New Delhi. We look forward to your insights and wisdom, sir. Please join me in welcoming His Lordship to address us.
Good morning. My esteemed colleagues in Karnataka High Court, Justice Sunil Yadov and Justice V. Shananda, Dr. J. Mallikarjunaya, Sri Jayanand Munawali, Dr. Gnaneshwar Chauri, who is the principal of the college, my other distinguished sister and brother judges of Karnataka High Court, members of the faculty, and students of law who are present here in large numbers. When I visit any law college, my mind goes back to 1980 when I joined Government Law College in Mumbai, which is the oldest law college in Mumbai. During last 44 years, I must say that legal education in India is one field where we have made vast improvements. I remember as a student of Government Law College, in those days, there were all part-time law colleges. And there used to be two courses. One was BGL, 2 years course, Bachelor of General Laws, which did not entitle you to practice. And there are 3 years LLB degree course. When I joined Government Law College, we used to barely have 2 lectures per day, sometimes very occasionally 3. There were no moot court competitions. I remember there was only one moot court competition in the college every year. There are no other competitions, not even debating events. Perhaps the reason was different. I must candidly say that 1980s were the days when it was openly said that those who do not get admission to any other professional school or college, as a last resort, people used to join law. Of course, I must hasten to add, I was not one of those students. With intention, I joined law course. And there was hardly any legal education. Only advantage of having admission in government law college was there are few guest lectures. And I remember Nani Palkhiwala, the great Indian lawyer and economist, addressing us on constitutional law. And there are 3 other advantages which government law college had. One was its closeness to Bombay High Court, where we used to have a lot of time, only 2 lectures. And in those days, I must hasten to add that attending lectures was not mandatory. So today is not the day when I should disclose how many lectures I was attending or my friends were attending. But we used to spend a lot of time in Bombay High Court hearing the submissions. All of you are conversant with a book on constitution by H.M. Sirvai. I heard Sirvai arguing a case before full bench of the Bombay High Court, hardly understood anything in those days. Many salvars were there. We had a beautiful British Council library very close to the Government Law College. I'm talking about 1980, where the British Council library used to have many good videos, many films, many informative videos about the universities abroad. There are speeches by great and remarkable personalities. And third and most important place, which was very near to Government Law College, was Wankhede Stadium, where we could spend 1 rupee, buy a ticket, and see Gavaskar, Vishwanath, Vengsarkar, Chandrasekhar all in action in Ranji Trophy and Duleep Trophy matches. From 90 onwards, when 5 years law courses were introduced, the legal education underwent a revolution. And I'm very glad to note now, I have traveled across India. Now, so many colleges have come up, law colleges which give quality education. I'm not referring to national law schools or those elite private law schools which have come up. I am on traditional law colleges. And talking about this law college, I visited their campus in Bangalore. I visited their campus in New Bombay. Fabulous facilities are extended by this society to law students. So today, I always say that you are privileged generation of law students. You are real privileges. I'm sure throughout the year you must be having many guest lecturers, sitting High Court judges coming, sitting Supreme Court judges coming, and academicians all over India. Therefore, I always say that present generation of law students is a privileged generation. Every time I visit law college, I'll tell you simple things how the things have changed. Today, I see all boys and girls wearing black coats. In my days, nobody would dare to go to our parents and ask money for having black coat. But now having black coat is something which is very important in legal education. And I see the qualitative difference also. I get many interns from law colleges all over India. In fact, in my chamber, the rule is out of 5 interns we take for every month, I always insist that minimum 2 have to be from traditional law colleges and not from law schools or those private laws, not from national law schools and private law schools. And I can see the difference. I always place myself in position of these interns. And I today see a 4th year student or 5th year student joining me as an intern. He has such a phenomenal knowledge of constitutional law. The students are able to pick up very complicated issues in taxation matters, in matters under IB code. As a student, my generation, we are far, far behind. Today's topic has some relevance with kind of excellent facilities which young law students get from the law colleges which exist today in 2024. The subject is career in judiciary. About the importance of legal profession, etc., I'm going to speak in the latter part of the day when I'm here in an evaluatory function. Today I'm here to impress upon young students to think or to start thinking process of taking up judiciary as a career. Maybe 30 years back, 40 years back, I don't think anybody was encouraging students to take up career in judiciary. The reason was the conditions of service in judiciary were far from being satisfactory. There are 3 of my colleagues here from Karnataka High Court, Justice Shishananda, Justice Uma, Justice Adiga. They'll be able to tell you how poor were conditions of service of our trial court judges. After advent of Shetty Commission judgment of the Supreme Court, the entire scenario has undergone change. Now, I must tell you, judiciary offers very good service conditions. Recently, after recent judgment of former Chief Justice of India, Dr. D.Y. Chandrachud, now a fresh law graduate who has no experience of practice because he has scored certain number of marks in LLM, he can enter judiciary at the age of 25, 26, 27. And after making deductions, all deductions, income tax, etc., today the pay which he gets in hand is something like 94,000, 95,000, plus all the other perquisites, rent-free accommodation, allowances for educating your children, free medical services or reimbursement of medical expenses. So many amenities are there. You get laptop, you get your iPad. So many facilities are there. Therefore, I always tell the young law students that you are far, far privileged than those who graduate from our traditional engineering colleges. In fact, morning I was discussing with my colleagues here that today we have a scenario where those who compete for civil services examination undergo that training, rigorous training, and they are posted as either IPS officers or IS officers or IRS officers. Their starting pay is somewhere between 75,000 to 80,000. Even so, therefore, a young law graduate who joins as a civil judge, he gets now a very, very reasonable salary and perquisites. Earlier, when I was a student, or maybe 20 years back or 25 years back, I have seen some of the professors in law colleges telling the students that, yes, you want to join judiciary, but please consider this. Your service conditions are not good. Now I can tell you that service conditions are very decent, very, very decent. And therefore, first thing is that when you think about a particular career, you always think about what will be your income. So if you are thinking in terms of joining judiciary, now poor service condition or some deficiency in service condition need not detain you. I can say with great deal of emphasis that service conditions are good. Now, some of you know that you can join judiciary at 2 stages. One, as a civil judge, and the second is as a direct district judge. About 25% of the posts of district judges are reserved for direct appointment to the post of district judges, where High Court conducts examination and interviews. And somebody who has practiced for 7 years, you can always compete for that examination. So there are 2 ladders. One ladder takes you at the grassroots level of the judiciary. The other ladder takes you at the slightly higher level of district and session judges. So opportunities are available to everybody. Even in judiciary, as I told you, there is a remarkable transition. Remarkable transition is that at one point of time in 80s, the service conditions used to be very poor. Now we have very decent service conditions. And one very remarkable distinction, remarkable change which is brought about during the last 20 years. Now you go to any state in India, barring few states in Northeast India. Now we have a scenario where 50% or more of judicial officers who are newly appointed are women, are girls. That's a very, very major development which has happened during the last 15 to 20 years. In fact, I remember I was associated with Maharashtra Judicial Academy. We had to introduce many changes to cater the needs of a young woman law graduate entering the judiciary as a judge. There were young judicial officers who were having infants, small children. So in Judicial Academy, we made a rule that a woman judicial officer who has a small child or infant, she can be accompanied in the campus either by her mother or mother-in-law. We allowed them to stay on the campus. And this is a very remarkable development which has happened in independent India, that so many young women law graduates joining judiciary. It has changed the entire picture of the judiciary. There are cases of offenses against women. The presence of women judges have brought about a change of approach. Another important thing which I noticed was I went to Patna about 2 years back to deliver a lecture in Patna Judicial Academy, where about 300 newly appointed judicial officers from 20 to 22 were present. Out of those 300 judicial officers, 64% were women officers, and there were about 30 or 31 who were alumni of national law schools in India from different parts. As I told you, in 90s, the legal education underwent change where the talent started coming back to law. Today, there are students who initially, that's one question you must be asking me. The first and foremost is, you must understand the ethos, the ideals of our constitution. In the preamble of our constitution, you will find that the framers of the constitution guarantee justice. And look at the concept of justice in our preamble. It's not justice in the court, social, economic, and political. That is the broad concept of justice which is assured to every citizen of this country. Now, justice has to be rendered not only by judges or the judiciary, justice has to be rendered by executive, where executive has to be fair, they are bound by Article 21. Justice has to be delivered by our law enforcing agencies by upholding the rights of citizens under Article 21 of the Constitution of India. Justice has to be rendered by all sections of society for upholding right of free speech and expression. But where does the role of judges come into picture? in terms of justice contemplated by the Constitution. The role of judges come into picture when our citizens are denied justice either by the executive, either by the police, or by society at large. There the role of judges come into picture. The judges exist because they have a duty. The duty, when there is dispute between two individuals, justice has to be done to one individual out of the two in whose favor the law of the land is. There is a remarkable difference between role of a judge and role of a lawyer, role of a judge and role of a lawyer. Of course, we need good lawyers also for our system. If you are a lawyer, if you are a successful lawyer, of course, you may get a lot of money. But there is inherent constraint on your performance. Because when you are a lawyer and you appear and argue a case or you conduct a trial, your performance is affected by several factors. The first factor is who is your opponent. The second factor is who is the judge. Third factor is how is your client. Because sometimes clients put you under such an enormous pressure that you are not able to act as per your conscience. You face a very, very vociferous opponent who will leave no opportunity to attack you in the court. Or sometimes you may face a very hostile judge. Now compare this with the position of a judge. Some of you will become civil judges, some of you will become district judges. When you sit on the chair of the judge, your action is not controlled by any third party. Your action is not controlled by lawyers who appear before you. Your action is not controlled by a member of your family. Your action is controlled by your judicial conscience and the law, the legal position or the legal concept. So when you sit as a judge, nobody can control your performance as a judge. If you are good, you will be able to deliver quality justice. And one thing, since I'm on this, I'll tell you from my own personal experience. I practiced law in district court for 2 years. Then almost for 18 years, I practiced law in Bombay High Court. And more than 20, which were my practice years, I'm a judge for 21 years. I must tell you very candidly, the work satisfaction which you derive as a judge, you will never get as a lawyer or never get in any other employment or any other venture you undertake for earning livelihood. The great satisfaction you get as a judge of doing justice, of extending helping hand of law to those who suffer injustice, or to seeing that when you see that somebody is really benefited by your judicial orders, that's a great satisfaction. One more thing which I always tell the students, somehow there's an impression carried in the mind of students, and especially those who are studying in law colleges in districts. The impression is that the legal practice in our trial and district courts is something which is inferior to the legal practice in High Court or Supreme Court. Another impression is that the judges of the constitutional courts, namely High Court and Supreme Court, you know, there's somebody who is superior to our judges in taluka and district courts. And therefore you wonder, what is the use of joining judiciary in district? I may or may not end up in High Court, I may retire as a district judge. Please remember one very important thing. The most important courts in India are, of course, constitutional courts are important, but the most important courts in India are our courts in districts, in taluka places, civil courts, criminal courts. They are the most important courts because they are common man's court. Other day, I was delivering similar lecture in one of the law schools. So when I said this, that our trial courts are perhaps more important and more crucial in our justice delivery system, somebody questioned me. One student said, sir, the higher courts, as constitutional courts, they can enforce the fundamental rights. And they are, after all, constitutional courts. I told the students that you are ignoring something which is very fundamental, which is the most important article under the Constitution of India, which is the most important fundamental right. According to me, my personal view is that the most important fundamental right is Article 21, right to life, which has been enormously expanded by the Supreme Court during the last 75 years. Our courts of judicial magistrate and session judges are the most important courts who are vested with the duty of upholding fundamental right of citizens under Article 21. What are the legal provisions? Some of you must be aware. If police arrest a person, the law mandates that within 24 hours he has to be produced before a judicial magistrate. The traveling time, etc., is deducted while counting 24 hours. If accused is not produced within 24 hours before the nearest magistrate, his arrest is rendered as illegal. And when arrested accused is produced before the judicial magistrate, a very, very crucial role has to be played by a judicial magistrate. At grassroots level, he is the first in the ladder of judiciary who ensures that Article 21 is implemented. He has to ensure that all safeguards which are there for arresting a person are complied with, before whom the investigating agency will pray for remand, police custody remand as we call it. And as you know, difference between the police custody remand and remand to jail, judicial custody as we call it. If an accused is remanded to police custody, very often, very sad, 77 years of after independence of and 75 years of existence of Constitution, even today, third degree methods are used against the accused who are given police custody. So it is at this level, your role is very important. First thing you have to ask the accused is whether he has been ill-treated while he was in custody of the police, whether he has suffered any injuries. And if you find that he has been ill-treated, he has suffered injuries, there are options available under the CRPC to ensure that the grievance of the accused is redressed. You are the ones, those who join judiciary and act as judicial magistrate, you are the ones who are, if you are careful enough, you ensure that minimum days of police custody is granted to an accused, and then accused is sent to the prison as in judicial custody. In our country, barring few statutes, the rule is golden rule laid down by Justice Krishna Iyer, that bail is the rule and jail is the exception. Judicial magistrates or session judges have to implement this golden rule, which is essential part of our jurisprudence under Article 21. You have power to ensure that nobody is detained, no under trial is detained, even a day more than what is required. And you can ensure that he is set at liberty. There is a provision in CPC, I think section 91, where any public-spirited person, one or more public-spirited persons with the leave of the court can institute a suit for enforcing the rights of the government, rights of the state as we call it broadly, the obligations of the state towards a common man. Look at those provisions. So somebody who is public spirited, 2 or 3 people can come together and file a suit with the leave of the court, where the civil court may not have power to issue mandamus, but civil court can pass a mandatory injunction. Civil court can grant prohibitive injunction against the government, against the executive. So therefore, don't be under impression that only the constitutional courts have a role to play when it comes to enforcement of fundamental rights. There are abundant powers vested in our trial courts and district courts for enforcing the fundamental rights. So place yourself in a position that you become a judge. You are dealing with criminal cases where most heinous offense is committed. If there is a legally admissible evidence which proves guilt of accused beyond reasonable doubt, it is your duty to ensure that guilty is punished and is adequately punished. That will give great satisfaction that some wrongdoer is visited with a penalty. We will also get a satisfaction that somebody against whom there is no legal evidence, he is roped in as accused and he is set at liberty by you. If you sit on the civil side, there are brothers who are fighting. There are people in our society, landlords, for example, they act high-handedly. They take forcible possession of the premises in possession of tenant. If a tenant files a suit before you or somebody, a small man who is dispossessed of his property otherwise than by due process of law, he can file a suit under Section 6 of the Specific Relief Act and come to you for restoration of his possession. And as a civil court, you have all the powers to do justice and to restore possession. Another area where you can render great service to the society. You know, in our Indian society, after independence, there are good and bad changes. One good change, as I told you in the beginning, is that now we have enormous improvement in terms of quality legal education. But one societal change which young students must notice is that the society has become different, and therefore we see large number of matrimonial disputes which are coming to the court. And what are those matrimonial disputes? There is one matrimonial dispute between husband and wife. You will find that there is one petition filed by husband or wife for divorce. The other party says, I want restitution of conjugal rights. Wife files a complaint under Section 498A of IPC, complaining about harassment because demand for dowry is not met. Wife will file a petition claiming maintenance under Section 125 of CRPC. Unfortunately, if there are children born, then there will be fight over custody of the children. So one matrimonial litigation leads to 4 or 5 cases at grassroots level. And now there is one more addition. Younger generation will understand better than me. Now the latest category of litigation in dispute between husband and wife is offense under IT Act, because husband and wife exchange that WhatsApp conversation. On the basis of that, either husband or wife, they prosecute the other spouse under the IT Act. The point is, these litigations are filed at grassroots level. And as judges, if you ensure that the dispute is amicably settled, you render a great service. What is that great service? If at grassroots level you are able to ensure that you are able to either bring husband and wife together, or there's a golden handshake, as we call their parties separate by taking decree of divorce, they settle all other disputes, maintenance, etc. You will be saving 25 litigations, because 5 litigations at grassroots level, then there are appeals to the revisions to the sessions court, appeals to the high court, SLPs, 25 litigations you save. And most importantly, you know, when there is one matrimonial dispute, 3 families are directly affected. One family, that small family of husband and wife, and if at all they have children, the children. One is the family of husband, other is the family of wife. So these are the cases. If you deal with such cases, you will get great satisfaction. There are cases where the wives are harassed, they are subjected to crimes. In such a case also, as judicial officers, you can come to rescue of such helpless women. So in short, what I want to tell you is that when you work as a judge, it will give you enormous satisfaction while you perform your duty to the best of your abilities. At the same time, considering the reasonable remuneration, the other perquisites which are now made available to the judicial post, otherwise also it's a good service to join. And now, I think just now we heard that K.L.E has conducted some kind of a drive. They are conducting courses. They are encouraging students to join judiciary. I was part of one such function, two such functions. So therefore, my appeal to you, the younger generation of students, is to please think of joining judiciary and joining judiciary at grassroots level. When I say that talent has come back to the to law, to education of law, and I see bright law students every day. They are so bright. Other day, a fifth-year law student who was an intern. He was from one of the districts in Maharashtra, coastal districts in Maharashtra. He told me one point while we were dealing with a case, a criminal case. He told me a very important point, and he said, "Sir, perhaps we'll have to concentrate on this point." So this kind of intellectual level which our young students have, and therefore it is all the more necessary for you to consider of joining judiciary. And that's the message which I wanted to convey to all of you. And I am glad that you are so many in number. And even if I see after 15, 20 years, some of you occupying post of district judges or even higher post judges, I'll be very delighted. So please keep this message in mind. And if time permits, we can have interactive session. So I thank the organizers and especially Dr. J. Mallikarjunaya for giving this opportunity to interact with so many young and bright law students who are present in large numbers. So I wish you a great success in whatever career you adopt. But I'll end by saying that please contribute to the nation in any form, maybe as a judge, maybe as a lawyer, maybe as a prosecutor or government advocate, but please contribute to the legal system. And that's of immense importance. Thank you very much.
Thank you, sir, for your enlightening words. Your address has truly inspired us to strive for excellence in our academic and personal endeavors, especially in choosing judiciary as career option. We are honored to invite our guest of honor, Honorable Mr. Justice V. Srishananda, Judge, High Court of Karnataka, to address the audience.
ಗುಡ್ ಆಫ್ಟರ್ನೂನ್ ಟು ಆಲ್ ಆಫ್ ಯು. ಸಭೆಗೆ ವಂದಿಸುತ್ತಾ there is a slight change in the protocol. Usually I should have spoken first, then Brother Justice Yadov, and then our mentor, beloved Honorable Justice Workshop. Between me and Justice Yadav, we decided that Workshop speak so that we are on the question of taking the shelter under Justice Work. Well, with the permission of the Honorable Justice Work, who can also follow Kannada, many of you have heard now what the roadmap so far as the career in the judiciary is concerned. Some of us are still not so fluent with the English, so I may have the liberty of addressing you in Kannada. ಸ್ನೇಹಿತರೆ, ಈ ಕಡೆ ಭಾಗದಲ್ಲಿ ಬಂದಿರತಕ್ಕಂಥ ಒಂದು ಪ್ರಖ್ಯಾತವಾಗಿರ್ತಕ್ಕಂಥ ಒಂದು ಗೀತೆ, ಕವಿ, ಧಾರವಾಡ ಅಂದರೆ ಹಾಗೇನೆ, ಈ ಕಡೆ ನಿಂತ್ಕೊಂಡು ಆ ಕಡೆಗೆ ಹೋಗಿದ್ರೆ ಆ ಕಲ್ಲು ಇನ್ನೊಬ್ಬ ಸಾಹಿತಿ ಮನೆ ಮೇಲೆ ಬೀಳುತ್ತೆ ಅಂತ. ಹಂಗೆ ಬಂದಂಥ ಒಂದು ಸ್ಥಳದಲ್ಲಿ ಓದಿ ಬ್ರಾಹ್ಮಣನಾಗು, ಕಾದು ಕ್ಷತ್ರಿಯನಾಗು, ನಿನ್ನೊಲವಿನಂತಾಗು, ಏನಾದರೂ ಸರಿಯೇ ಮೊದಲು ಮಾನವನಾಗು ಅಂತ ಹೇಳಿ ಇರ್ತಕ್ಕಂಥ ವ್ಯಕ್ತಿ. ನಾವೆಲ್ಲ ಮನುಷ್ಯರಾಗಿ ಹುಟ್ಟಿದ್ದೇವೆ. ಪ್ರಾಣಿಗಳಿಗಿಂತ ಹೆಚ್ಚಿನ ರೀತಿಯಾಗಿರ್ತಕ್ಕಂಥ ಎರಡು ಅಡ್ವಾಂಟೇಜ್ ನಮಗಿದೆ. ಮೊದಲನೇದು ಮಾತಾಡಕ್ಕೆ ಬರುತ್ತೆ, ಪ್ರಾಣಿಗಳಿಗೆ ಬರಲ್ಲ. ಎರಡನೇದು ನಗಕ್ಕೆ ಬರುತ್ತೆ. ಯಾರು ನಗ್ತಿಲ್ವೇ? ಇವೆರಡು ನಮ್ಮ ವಿಶೇಷವಾಗಿ ಮನುಷ್ಯನಲ್ಲಿರ್ತಕ್ಕಂಥ ಗುಣಗಳು. ಸಂವಹನ, ನನ್ನಲ್ಲಿ ಏನಾಗ್ತಿದೆ ಭಾವನೆ, ಅದನ್ನು ಪ್ರಾಣಿಗಳು ಕೂಡ ಇನ್ನೊಂದು ಪ್ರಾಣಿಗೆ ವ್ಯಕ್ತಪಡಿಸುತ್ತೆ. ಆದರೆ there are two words in English, sympathy and empathy ಅಂತ. ಇದೇ ಭಾಗದ ಸರ್ವಜ್ಞ ಹೇಳಿದಂಥದ್ದು, ಅನ್ನವನ್ನು ಇಕ್ಕುವುದು, ನನ್ನಿಯನ್ನು ನುಡಿಯುವುದು, ತನ್ನಂತೆ ಇತರರ ಬಗೆದೊಡೆ, ಕೈಲಾಸ ಭಿನ್ನಾಣವಕ್ಕೂ ಸರ್ವಜ್ಞ ಅಂತ. ದಟ್ ಈಸ್ ಆಲ್ ಎಂಪತಿ ಅಬೌಟ್ ಅಂತ. ಅನ್ನ ಇಕ್ಕೋದು ಅಂದರೆ ಗೊತ್ತು, ನನ್ನಿಯನ್ನು ನುಡಿಯುವುದು ಅಂದರೆ ಭಾಳಷ್ಟು ಜನಕ್ಕೆ ಇಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ. ನನ್ನಿ ಅಂತಂದರೆ ಬೇರೆ ಏನಲ್ಲ, ಸತ್ಯವನ್ನು ಹೇಳ್ತಕ್ಕಂಥದ್ದು ಅಂತ. ತನ್ನಂತೆ ಇತರರ ಬಗೆದೊಡೆ, ಕೈಲಾಸ ಭಿನ್ನಾಣವಕ್ಕೂ ಸರ್ವಜ್ಞ ಅಂತ. ಟ್ರೀಟ್ ದಿ ಅನದರ್ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ ಲೈಕ್ ಎ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್, ದಟ್ಸ್ ಆಲ್ ದಿ ರಿಕ್ವೈರ್ಮೆಂಟ್. ಯು ಡೋಂಟ್ ರಿಕ್ವೈರ್ ಎನಿ ಹೆವೆನ್ ಅಟ್ ಆಲ್ ಅನ್ನೋದ್ರ ಆಂತರ್ಯ ಅದು. ಅದಾಗಬೇಕಾದ್ರೆ ನಮಗೆ ಬೇಕಾಗಿರುತ್ತಂಥದ್ದು, ಹುಟ್ತಾ ಮನುಷ್ಯರಾಗ್ತೀವಿ, ಬೆಳೀತಾ ನಾವ್ಯಾಕೋ ರಾಕ್ಷಸರಾಗ್ತಿದ್ದೀವಿ, ವ್ಯಾಲ್ಯೂ ಇನ್ ದಿ ಸೊಸೈಟಿ ಡಿಟರೇಟ್ ಆಗ್ತಿದೆ ಅಂತ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ವೋಗ್ ಸಾಹೇಬ್ ಹೇಳಿದ್ರು. ಸೊಸೈಟಿ ಹ್ಯಾಸ್ ಅಂಡರ್ಗಾನ್ ಎ ಫೆನಾಮಿನಲ್ ಚೇಂಜ್ ವೈಲ್ ದಿ legal education has also undergone a phenomenal change anta. Therefore, there is a big challenge to meet this phenomenal value system in the society with the existing laws, and for which a judge with a full legal acumen to understand under the humanitarian values and levels to deal with the changed values-based system in this society. Saab has also told the several types of litigation that has come up, recent being the exchange of WhatsApp. Lordship was modest enough. It was not only the question of the messages in WhatsApp. Many of our young friends are now attracted to what is called dating app. Please look at it. You exchange your private moments, intimate moments. Every day today, I see whenever a 65 violation, 69 of the IT Act, I only see your friends misutilizing your private moments. Moment there is a breakup, the entire thing goes in the viral. There are suicides, young girls committing suicide, young boys are also committing suicide. My dear friends, what is happening? What was to be there within the four corners, how it has gone viral. And today one picture, tomorrow another picture. Life gone is gone. So therefore we need such talents to deal with these type of things. We had the traditional cricket. Saab was mentioning about the Wankhede Stadium, 1 rupee, all these things were there. Well, in my days, if the ball is to go, say about 6 inches away from the off stump, I would leave it. That's how the Dravid played. Today it is not so. We have now invented what is called reverse swing, shining the ball on one side and making it lose its shine on the other side. There was a conversation between Dravid and Tendulkar. It was a foreign tour as usual. 2-3 wickets had already gone. They were unable to spot the ball. Now, when they were unable to spot the ball, the discussion went on in between them. What is happening? I am not able to spot the ball. You know, the 21 yards is the pitch. 120, 130, 140 kilometers an hour, the ball is thrown. You have a split second at your command to choose the shot and play it, provided you spot the ball. Now what happened is, both the batsmen in the over break had a discussion each other. I am not able to spot the ball. The non-striker also says that was the problem with me. The second and third or fourth delivery, somehow I was able to survive. Now there is a discussion between Tendulkar and Dravid. They decide, all right, now you are at the non-striker end. You can see the ball, which face that the bowler is holding in his hand, so that when it is delivered, whether it is the shiny face or the non-shiny face, that would reach me. So you can caution me. So Tendulkar said, he was the non-striker, if it is a shiny side, I'll hold the bat on the left side. And if it is non-shiny, I'll hold the bat on the right side. Now with this, the things would have been easy. There was third option. What if the non-striker also doesn't see which type of the ball that he is holding? He says, I'll hold the bat in the center. Do whatever you want. You may ask me how this particular example is relevant to our legal system or the judging process. Reverse swing was not known when traditional 2-year LLB or 3-year LLB was there. Now when the 5-year LLB has come, this reverse swing has started. So there is a onerous responsibility on us, especially those who want to take up the judiciary. Well, now what happened in the next over was, this worked and there were back-to-back boundaries. Bowler was perturbed. The trick was out. What made the judging process? ಸ್ನೇಹಿತರೆ, ಇಲ್ಲಿ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಶಿಕ್ಷಾವಳಿ ಅಂತ ಹೇಳಿ ನಮ್ಮಲ್ಲಿ ಕಾನ್ವೊಕೇಶನ್ ಅಡ್ರೆಸ್ ಇತ್ತು. ಬೃಹದಾರಣ್ಯಕೋಪನಿಷತ್ತಿನ ಭಾಗ ಅದು. ಅಲ್ಲಿ ಹೇಳ್ಕೊಡ್ತಾರೆ, ಕಮ್ ವಾಟ್ ಮೇ, ಡೋಂಟ್ ಗಿವ್ ಅಪ್ ಯುವರ್ ಬೇಸಿಕ್ಸ್ ಅಂತ. ಧರ್ಮಾತ್ನ ಪ್ರಮದಿತವ್ಯಂ, ಕುಶಲಾತ್ನ ಪ್ರಮದಿತವ್ಯಂ, ಭೂತ್ಯೈನ ಸ್ವಾಧ್ಯಾಯ ಪ್ರವಚನಾಭ್ಯಾಂ ನ ಪ್ರಮದಿತವ್ಯಂ. Well, Sanskrit is good. I can fluently speak Sanskrit. What about you? How many of you understood? Very few. Swadhyaya pravachanabhyam na pramaditavyam is the important thing that I'll take there for the paucity of the time at my command. When the pitch was there, when the coach, either Ramakant Archekar or somebody has coached the Tendulkar or Dravid, they did not know this reverse swing how to play. So they have inculcated that particular on the spot, and they have understood by Swadhyaya, that is self-learning. ಅದನ್ನ ಅವರೇ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ಮುಂದಿನ ಸತಿ ಬ್ಯಾಟ್ಸ್ಮನ್ ಫೇಲ್ ಆಗ್ಬಿಡೋನು. ಅವರಿಬ್ಬರ ಮಧ್ಯ ಪ್ರವಚನ ಅಂತ ಆಯ್ತು. ಪ್ರವಚನ ಅಂದರೆ ಬೇರೆ ಏನು ದೊಡ್ಡದಲ್ಲ, ಪುರಾಣ ಅಂತಲ್ಲ. ಮೀನ್ಸ್ ಎ ಸಿಸ್ಟಮ್ಯಾಟಿಕ್ ಪ್ರಾಪಗೇಷನ್ ಆಫ್ ದಿ ನಾಲೆಡ್ಜ್ ಅಂತ. ಸಿಸ್ಟಮ್ಯಾಟಿಕ್. ಯಾವಾಗ ಅಂತ ಬರುತ್ತದು. ವಚನ ಅನ್ನೋದಕ್ಕೆ ನಿಮ್ಗೇನು ಹೇಳಬೇಕಾಗಿಲ್ಲ. ವಚನದ ನಾಡಲ್ಲಿ ನಾವು ನಿಂತಿದ್ದೀವಿ. ವಚನ ಅಂದರೆ ಬರೇ ಮಾತಲ್ಲ, ಟೈಮ್ ಟೆಸ್ಟೆಡ್ ಟ್ರುತ್ ಅಂತ. ಯಾವ ಟೈಮ್ ಟೆಸ್ಟೆಡ್ ಟ್ರುತ್ನ ನೀವು ಸಿಸ್ಟಮ್ಯಾಟಿಕ್ ಆಗಿ ಕಲ್ತ್ಕೋತೀರಿ, ಆವಾಗ ಅದ್ರಲ್ಲಿ ಬರ್ತಕ್ಕಂಥ ಸಂಪೂರ್ಣ ಸಾರವನ್ನು ನಾವು ಹೀರ್ಕೊಂಡ್ಬಿಡಬಹುದು ಅಂತ. ದಟ್ ಈಸ್ ವಾಟ್ ರಿಸಲ್ಟೆಡ್ ಇನ್ 3-4 ಬೌಂಡ್ರೀಸ್ ನೆಕ್ಸ್ಟ್ ಓವರ್, ಮೇಕಿಂಗ್ ದಿ ಬೌಲರ್ ಪರ್ಟರ್ಬ್ ಅಂಡ್ ದಿ ವೆರಿ ಕ್ಯಾಪ್ಟನ್ ಪರ್ಟರ್ಬ್ ಟು ರಿಮೂವ್ ಹಿಮ್ ಫ್ರಮ್ ದಿ ಬೌಲಿಂಗ್. ಈಗ ನಮ್ಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇದೆ, ಹೊಸ ಸವಾಲುಗಳು ಬರ್ತಾ ಇದೆ ಸಮಾಜದಲ್ಲಿ. ಹೊಸ ಸವಾಲುಗಳು ಬಂದಾಗ ಆ ಹೊಸ ಸವಾಲಿಗೆ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥ ನಮ್ಮಲ್ಲಿರ್ತಕ್ಕಂಥ ಬುದ್ಧಿವಂತಿಕೆಯನ್ನು ಹೇಗೆ ಉಪಯೋಗಿಸೋದು. ಬುದ್ಧಿವಂತಿಕೆಯನ್ನು ಉಪಯೋಗಿಸುವಾಗ ಕಾನೂನು ಎಲ್ಲೂ ಸೋಲ್ಬಾರ್ದು, ಸತ್ಯ ಎಲ್ಲೂ ಸೋಲ್ಬಾರ್ದು. ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ಸೀನಿಯರ್ ಮಳಿಮಠ್ ಅವರು ಅವರ ಒಂದು ರಿಫಾರ್ಮೇಷನ್ ಆಫ್ ದಿ ಕ್ರಿಮಿನಲ್ ಲಾಸ್ ಅನ್ನೋ ಒಂದು ಪುಸ್ತಕದಲ್ಲಿ ಬರೀತಾರೆ, ಇನ್ ಎವರಿ ಟ್ರಯಲ್ ವಾಟ್ ಈಸ್ ದಿ ಗೋಲ್ ಅಂತ. ಟ್ರಯಲ್ ಈಸ್ ಎ ಓಯೇಜ್, ಅಂದರೆ ಒಂದು ಪ್ರವಾಸ. ಒಂದು ಯಾವುದಾದ್ರು ಒಂದು ವಿಚಾರಣೆ ನಡೆದ್ರೆ ಅದೊಂದು ಪ್ರವಾಸ. ಗಮ್ಯವಾದ ಸ್ಥಳ ಯಾವುದಿರಬೇಕು ಅಂದರೆ, ಇಟ್ ಈಸ್ ದಿ ಟ್ರುತ್ ದಟ್ ಶುಡ್ ಬಿ ದಿ ಯುವರ್ ಗೋಲ್. ಕನ್ನಡದಲ್ಲಿ ಸ್ವಚ್ಛಾಗಿ ಹೇಳೋದಾದರೆ, ಸತ್ಯಾನ್ವೇಷಣೆಯೇ ಆ ಒಂದು ಪ್ರವಾಸದ ಪ್ರಮುಖ ಗುರಿಯಾಗಿರಬೇಕು ಅಂತ. ಇವನು ತಪ್ಪು ಮಾಡಿದ್ದನ್ನೋ ಮಾಡಿಲ್ವೋ, ಇವನಿಗೆ ಈ ಅನುಕೂಲತೆಗಳು ಸಿಗಬೇಕೋ ಬೇಡವೋ, ಇಂಥ ವಿಚಾರಗಳನ್ನೆಲ್ಲ ನಾವು ಒಂದು ಪ್ರವಚನ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅದೇ ಥರನೇ ಶಿಸ್ತುಬದ್ಧವಾಗಿ ಹೀಗೀಗೆ ಮಾಡಬೇಕು ಅಂತ ಒಂದು ಲೆಕ್ಕಾಚಾರದ ಮುಖಾಂತರ ಕಾನೂನಿನ ಚೌಕಟ್ಟನ್ನು ಮೀರದ ಹಾಗೆ ಮಾನವೀಯತೆಯನ್ನು ಉಳಿಸ್ಕೊಳ್ಳೋದ್ರಲ್ಲಿ ಜಡ್ಜಸ್ಗಳ ಪಾತ್ರ ಪ್ರಮುಖವಾಗುತ್ತೆ. ಯಾಕೆಂದರೆ ಎರಡೂ ಕಡೆ ಪಾರ್ಟಿ ವಕೀಲರನ್ನ ಹಣ ಕೊಟ್ಟು ತಮ್ಮ ತಮ್ಮ ಕೇಸನ್ನು ನಡೆಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿರ್ತಾರೆ. ಎಲ್ಲಿ ಸತ್ಯ ಅಡಗಿ ಹೋಗಿದೆ, ಎಲ್ಲಿ ಸತ್ಯ ಹುದುಗಿ ಹೋಗಿದೆ, ಅದನ್ನ ಹುದುಗಿ ಇರ್ತಕ್ಕಂಥ ಸತ್ಯವನ್ನು ಹೊರತೆಗೆತಕ್ಕಂಥ ಅತ್ಯುತ್ತಮವಾದ ದೈವಿಕ ಕಾರ್ಯವನ್ನು ಮಾಡ್ತಕ್ಕಂಥ ಏಕೈಕ ಶಕ್ತಿ ಇರ್ತಕ್ಕಂಥದ್ದು ನ್ಯಾಯಾಧೀಶರಿಗೆ ಮಾತ್ರ. ಆದ್ದರಿಂದ ಜುಡಿಷಿಯಲ್ ಕೆರಿಯರ್ ಅಂತಂದ್ರೆ ಎಲ್ಲರೂ ಆಗಕ್ಕಾಗೋದಿಲ್ಲ. ಅದನ್ನೇ ಮಾಡ್ತೀನಿ ಅಂತ ಯೋಚನೆ ಮಾಡಬೇಕಾದ್ರೆ ವಿದ್ಯಾರ್ಥಿ ದಶೆಯಿಂದಲೇ ನಾನೊಬ್ಬ ಜಡ್ಜ್ ಆಗಬೇಕು ಅಂತ ಮನಸ್ಸು ಮಾಡ್ತು ಅಂತಂದರೆ ಅದಕ್ಕೆ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥ ಪರಿಕರಗಳನ್ನು ಒದಗಿಸಿ ಕೊಟ್ಟಿರ್ತಾರೆ. 4ನೇ ವರ್ಷದಲ್ಲಿ 3ನೇ ವರ್ಷದಲ್ಲಿ ಪ್ರಾರಂಭ ಆಗ್ತಕ್ಕಂಥ ಇಂಥ ಲೆಕ್ಚರು ಮುಂದೆಂದೋ ನನ್ನ ಕನಸು ಹೀಗಿದೆ ಅಂತ ಆಗ್ಬೋದು. 23 ವರ್ಷದ ಹುಡುಗಿಗೆ ಮುನ್ಸಿಫ್ ಆದಾಗ ಊರವರೆಲ್ಲ ಕರೆದು ಸನ್ಮಾನ ಮಾಡಿದ್ರು. ನನ್ನ ಕಾಲದಲ್ಲಿ ಪೇಪರ್ನಲ್ಲಿ ಒಂದು ಮೂಲೆನಲ್ಲಿ ಇಷ್ಟು ಹೆಸರು ಬಂದಿದ್ದು ಬಿಟ್ಟರೆ ಗೊತ್ತೇ ಆಗಲಿಲ್ಲ ಯಾರಿಗೂ ನಾನು ಜಡ್ಜ್ ಆಗಿದ್ದೆ ಅಂತ. ಇವತ್ತು ಆ ಪ್ರಾಮುಖ್ಯತೆ ಸಿಗ್ತಾ ಇದೆ. ಹೆಚ್ಚೇನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನಿಂದ ಕರ್ಕೊಂಡು ಬಂದು ನಮಗೆಲ್ಲ ಮೆಂಟರ್ ಅವರು. ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸೀನ್ ಎ ಫೆನಾಮಿನಲ್ ಚೇಂಜ್ ಇನ್ ದಿ ಜುಡಿಷಿಯಲ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಸಿಸ್ಟಮ್ ಇನ್ ದಿ ಪೀರಿಯಡ್ ಆಫ್ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ವರ್ಕ್, ಎಸ್ಪೆಷಲಿ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೀರಿಯಡ್ ಆಫ್ ಕೋವಿಡ್. Across the world, I am not talking of the India, across the world, courts had stopped functioning. We had Honorable Justice Work who dreamt, yes, we cannot close down the court at any given point of time. Closing the court is asking the heart to stop. No, it can't go on. Something we must do it. So we conceptualized, it is the brainchild of Honorable Justice Work to commence what is called hybrid hearing. If the Muhammad cannot go to the mountain, why not mountain come to the Muhammad? Was the principle. So we reached the litigant in the forum of hybrid hearing through VC. So much so that that has become the order of the day even in the Supreme Court today. So it is one man's dream which ultimately worked out. How it is possible? Had it been a lawyer, was it possible? Because the Honorable Chief Justice took this decision, we were all bound by it, and the results we are seeing today. Any nook and corner in the world we can sit and participate in the hearing. All these things are permissible because one person, one judge with a human mind could go back to the society and pay back to the society. ಕೆರೆಯ ನೀರನ್ನು ಕೆರೆಗೆ ಚೆಲ್ಲಿ ವರವ ಪಡೆದವರಂತೆ ಕಾಣಿರೋ ಹರಿಯ ಕರುಣೆಯಳಾದ ಭಾಗ್ಯವ ಹರಿಸಮರ್ಪಣೆ ಮಾಡಿ ಬದುಕಿರೋ ಅಂತ ದಾಸರು. ಈ ಸಮಾಜದಿಂದ ಇದ್ದೀವಿ ನಾವು. ಇವತ್ತೆಲ್ಲ ನಿಮ್ಮ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು, ತಮಗೆಲ್ಲ ಪುಣ್ಯವಂತರಾಗಿರ್ತಕ್ಕಂಥ ತಂದೆ ತಾಯಿಗಳು ಸಿಕ್ಕಿದ್ದಾರೆ. ಎಂಟೈರ್ ಮೈ ಕೆರಿಯರ್ ಆಸ್ ಎ ಲಾಯರ್, ಐ ಮೀನ್ ದಿ ಲಾ ಕೋರ್ಸ್, ಐ ಫಿನಿಶ್ಡ್ ಇನ್ 5,000 rupees. ಐ ಆಮ್ ಪೇಯಿಂಗ್ 2 lakhs per year for my son. 5,000 was my entire examination fee, everything. Why I am stressing all these things is, it is no longer a last resort for all of us. It is a career now. It is a profession now. My dear friends, 2 professions across the globe are called noble professions. One is the doctor profession and the other one is lawyer profession. Both of us can save a life when it is in peril or danger. Now, among the 2, I am a little bit, selfish. I being the lawyer, I being the judge, I belong to this community, this fraternity. Well, I say among the 2, lawyer profession is still a noble one. How? We never call a learned doctor. Have you called anybody as a learned doctor? No. Whereas a new entrant, tomorrow registering the sanad and then comes before me, we call it my learned friend. Whether he has learned it or not is a different issue. We call them as learned friend. We had Vikramaditya at our command. In his period, even the animal had the right to approach the court of law with a bell. Unfortunately, with some amount of reluctance, we cannot hide the truth any longer. Many times it is a now no bell profession, not noble profession. My dear friends, ಇಷ್ಟೆಲ್ಲ ಇನ್ನು ವಿಚಾರಗಳು ಹೇಳಕ್ಕಿದೆ. ಸಂಸ್ಥೆಯವರು ತಮಗೆಲ್ಲ ಕರೆಸಿ ಮೋಟಿವೇಟ್ ಮಾಡಿಸಿ ಹಲವಾರು ಸಂದರ್ಭದಲ್ಲಿ ಉತ್ತಮವಾಗಿರ್ತಕ್ಕಂಥ ನಿಮ್ಮ ಆಯ್ಕೆಯನ್ನು ಯಾವ ರೀತಿ ಮಾಡ್ಕೋಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇವತ್ತಿನ ಸಂಬಂಧಕ್ಕೆ, ಇವತ್ತಿನ ಚರ್ಚೆಗೆ, ಇವತ್ತಿನ ಉಪನ್ಯಾಸದ ವಿಷಯಕ್ಕೆ ನ್ಯಾಯಾಧೀಶರು ಆಗೋದು ಹೇಗೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಅಷ್ಟೇ ಸೀಮಿತವಾಗಿರ್ತಕ್ಕಂಥದ್ರಿಂದ, ಸಮಯ ಕೂಡ ಮುಗಿತಿರ್ತಕ್ಕಂಥದ್ರಿಂದ ನನ್ನ ಒಂದು ಉದ್ದೇಶ ಇಷ್ಟೇ. ಏನಾದರೂ ಸರಿಯೇ ಮೊದಲು ಮಾನವನಾಗೂ ಹೇಳಿದ್ವಿ. ಆ ಮಾನವೀಯತೆಯುಳ್ಳ ಒಬ್ಬ ಜಡ್ಜ್ಗಳು ಇಲ್ಲಿ ನನಗೆ ಕಾಣ್ ಬರ್ತಾ ಇದ್ದಾರೆ. ಎಷ್ಟೋ ಜನ ಇದ್ದೀರಿ. ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು 20 ವರ್ಷ ಅಂತ. ನನಗೆ ಅಷ್ಟೊಂದೆಲ್ಲ ಕಾಯೋಷ್ಟು ಪೇಷನ್ಸ್ ಇಲ್ಲ. 5-6 ಇಯರ್ಸ್ ಆದಮೇಲಿಂದ 2-3 ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಆಗಿದ ತಕ್ಷಣನೇ ನಮ್ಮಲ್ಲಿ ಯಾರು ನಮ್ಮ ಯೂನಿಟಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತಂದರೆ ಐ ಆಮ್ ದಿ ಹ್ಯಾಪಿಯೆಸ್ಟ್ ಪರ್ಸನ್. ಐ ಆಮ್ ಆಲ್ಸೋ ಲಿಟಲ್ ಸೆಲ್ಫಿಶ್. My time, Honorable Justice time, and the time of all of you will not come back in our life again. I have invested some time today. The 7th of December 2024 will never come back to me in my life again. This I have invested as the premium. I want dividend in the form of at least 1/3 of this gathering should be in the form of in the judiciary as my judges, my colleagues in the district judiciary. With that fond hope, I thank one and all.
Thank you, sir, for your inspiring words. We are honored to invite our guest of honor, Honorable Mr. Justice V. Siddhappa Sunil Dutt Yadav, Judge, High Court of Karnataka, to address the students.
Respected Justice Oak, Justice Shananda, the Sri Mallikarjunaya, the other members, dignitaries on the dais, and friends. It's indeed a unique opportunity to be in the midst of who you want to be, to emulate, I would say, the Judge, Justice Oak. Following of his judgments would give an insight to what a judge can do. It's indeed a great opportunity to become a judge, and a judge either at the entry level where you can write an exam and become a civil judge without any experience you can write. Then you have a second option of being a district judge after having practiced of about 7 years, then attempt the district judge's exam, or you can even become a high court judge, maybe after about 20 years of practice, if they recognize you and your competence and performance, or you can be directly elevated to the Supreme Court, which is also an option. Now, this is the world in front of you, and the journey starts now, and not necessarily after you finish your 5 years, but it is now. And now I say is that you have an opportunity to do your internship, to be exposed and to experience the different options, so that by the end of the 5th year, you can make up your mind, what is it that I want to become? And amongst them, I would rank that the option of becoming the judge is the highest and best option. And why? May I ask myself, is a question that you will ask because it's a contribution that you make for society. It's not only an option for a livelihood. Existence is for everybody. An animal lives, a plant lives, a human being lives. But it is a choice of having a qualitative life. And what is it I want to be? And I can say that the greatest option to render justice is by a judge. And a judge at the entry level touches the heart and lives and is a point of first contact, be it arrest when bail is sought, or before the sessions court when you convict and have the right to impose even of death sentence, or when you grant an injunction to save interference in one's property. And these roles as a judge that you perform as an entry-level judge at the very beginning is something which sometimes even the constitutional judges cannot. So just as Justice Oak has put in, it's a matter of great public duty, a duty that you owe towards a nation. And once you feel that I have to contribute to nation building, then I would like to say that amongst the options available for career, either in the executive or in the legislative or before the judiciary, the first preference will be as that of the judiciary, and its performance in safeguarding life, liberty has always been recognized to be a duty that the judiciary has performed far better, I could say, than what we would have expected. Friends, this is an opportunity for all of you to be a part of this process where the judiciary not merely is an adjudicatory system of rendering justice, but many a time is a tool for social engineering. And it is in this context that the constitutional courts have contributed greatly in interference with the action of the other wings, in furthering fundamental rights, in putting forth directions to ensure that we have a better world, that the rights under Article 21, the duties in the nature of fundamental duties, the obligations on the state under Article 39 are put into effect. All of you have the fortune of being exposed to a good educational system with the era of internet. You can watch the arguments of the best of the lawyers before the apex court, and these are the changes that have come. But apart from this, we need to develop the art of analyzing, the art of trying to understand how our constitutional goals are structured in our constitution. We are not merely a democracy, but a constitutional democracy, and we need to imbibe those values that are enshrined in the preamble as well as in the other chapters of the Constitution. If we were to say that our democracy has a rule of law, judiciary has contributed greatly, and you as citizens can also become a part of this process of contributing towards strengthening democracy, rule of law, and protecting the interests of the weakest. Lastly, in this small talk, I would like to just give a small example of what Justice Oak stated of tremendous emotional satisfaction that you will not get in any other work that you do. A simple example of a case for compassionate appointment. Case was filed. It involved a case where a father of a Paura Karmika had died. And the application was rejected on the ground that it was filed beyond time. And the facts were that this Paura Karmika's son had approached the authority stating his father had died and that he wanted a job. And the letter made me move. And the letter said, please give me a job as a guard in a graveyard. And what happened was there was a family feud. And when he went and approached for the job, they said, you solve your family dispute and come back. And by the time he solved and came back, the application, they said, you take it back, file a fresh one because it's late. He took it back and refiled it. And then they gave an endorsement. It was time barred. So the case came up before the High Court. And the argument that was put was I was misled into withdrawing it. I was not worldly wise. But what moved me was that letter, which nobody highlighted. But when I saw where he said, give me a job as a guard in a graveyard. And then I just thought for a moment and involved an interpretation which I would not have done in any other case. And then stated that the second application given, though after time, was a continuation of the first. And when I realized that the relief that I gave was for the most deserving, the satisfaction I get while passing such judgments, which are numerous in nature, far outweighs the other judgments I would have written analyzing law and the principles of law. This is only a small example of how judges reach out to those who are the weakest. With this, I leave it open for you to think about it, that if you aim to become a judge, definitely you'll be a good lawyer. Thank you.
Now, there will be a 10 minutes of interactive session. We encourage each one of you to actively participate in this interactive session. Kindly reserve your questions. Assistant Professor Sharda G. Patil will facilitate by passing the mic to interested candidates. Kindly keep your questions brief and direct. Related to the topic of today, avoid repetitions and follow-up questions.
You can come over here to avoid the time. Save the time, you can come over here. Yes, please. Yeah. If you are here, you can go this way.
Good morning, sir. I'm Raghavendra from the GKL Law College, sir. My question is regarding UCC, sir. So, is this the time to implementation of UCC in present days? And what is your suggestion regarding implementation of UCC, sir? Thank you, sir.
So, first you tell me, what do you feel about it?
Sir, I feel it is very good to have UCC in the present state, sir. And it is very, very important to bring the harmony in the nation, sir.
Right. But what is the concept of UCC according to you?
UCC about means the basic law says that everyone should be ruled under same law. That's what my intention, sir, and it is my will also. So everyone should be ruled under the same law. But present scenario, while I'm the secondary student, I'm studying different law, sir, but I'm not getting equal law for every man. Somewhat some discrimination is there in present day, sir.
It's a very good and interesting question, but there are 2 or 3 things you must understand and know. One is we have a concept of secularism in our constitution. Now, what is secularism? Secularism is that one way of looking at secularism is nobody will be discriminated on the ground of religion, and every religion is the same. The state should treat, state as we call it, executive or state should treat every religion as the same. Every religion should be treated fairly. Now, secularism is one concept. The other concept is of fraternity, which is very important in our preamble. One thing you must have noticed, 75 years of existence of constitution. There was one more country which became independent on the same day, our neighbor. You will find that because by and large, we implemented our ideals under the constitution. See, look at India. How many religions India has? How many languages? Every state is different. You are in Karnataka today, go to Assam or go to Sikkim or go to Jammu and Kashmir. There's so much of diversity. And the constitutional principles have kept this nation together. It's a very ideal situation. What you say is correct. But do we live in ideal world? What we have to consider is, yes, someday you're right, that can be object, uniform civil code or common civil code. But we have to assess whether stage has come in independent India to have uniform civil code. We cannot have a situation where we have a uniform civil code and that leads to disharmony. or that creates a situation where we forget fraternity. So these are the situations which we dream. But when you talk about the entire nation, we have to think about what should be the priority before us. See, today we talk in terms of Article 21, for example, that every citizen has right to lead dignified life, which will include right to shelter, right to education, right to health services. In our country, look at the situation. There are so many people who live in slums, so many people who live in streets. They are not, their children don't get education. They are not, they don't get medical facilities. So therefore, what is important before us today, we have to give priority to that. The priority should be to ensure that every citizen of India gets a shelter. Every citizen of India is able to exercise, boys and girls are able to exercise right to get education, right to health. A right to health is possible only when you get medical help. So I am not a politician. I am not a person who is part of the executive. But you have many dreams under the constitution. So which dream, implementation of which dream is to be given priority? That's the question we'll have to apply our mind. And you will get answer if you apply your mind. What should be the priority today in independent India after 75 years of constitution?
Thanks.
Respected sir, this is Manjunath HM, third year LLB K.L.E College student. Sir, what are the most rewarding aspects of a career in judiciary? And sir, what keeps you motivated, sir?
Most rewarding aspect, I'll tell you, the satisfaction you get by doing justice to parties before you. And that's, I don't think, as Brother Sunil also put it, Brother Shanda put it, I don't think any other job in the world will give you this kind of a satisfaction. Now, doing your duty to best of your abilities, doing your duty without compromising on your judicial integrity, and doing justice. Now, doing justice, has important facet. When you act as a judge, you have to show courage of deciding a case in accordance with law, though you yourself may not like the outcome, because you are bound to decide a case in accordance with law. So deciding a case in accordance with law, deciding a case which will give relief to common man in the sense that somebody is struggling to establish his right. I'll give an example. A widow is ousted from the joint Hindu family. You give justice to widow by saying that, yes, you have a share in the property, joint family property. Other members of the family must maintain you out of that share. So the enormous satisfaction is of doing justice. And I don't think when you are doing justice, the kind of satisfaction you get, any other motivational factor is required to keep on going.
Sir, another question.
Yes.
Sir, can you explain the importance of judicial independence in this current democratic society, sir?
Actually, I need not elaborate on this. To put in 2 or 3 sentences, if our constitution is to survive, only way it can survive is by judicial independence. So it is as important, of course, it is held to be part of basic structure also. As important is on pedestal of basic structure. So judicial importance is something which is utmost important in democratic India, because democracy will survive if there is judicial independence. Common man will be able to exercise their freedoms if there is judicial independence.
Thank you, sir.
My dear friend, we had a detailed discussion at the very high level among the High Court judges and Supreme Court judges a decade earlier, maybe 1.5 decades earlier in Bangalore. It is now called across the country, even across the globe, Bangalore principles. The first principle is the independence of judiciary, and my lord is the epitome and icon of judicial independence.
Thank you, sir.
And one more thing. Now, you are a law student. You'll become a law graduate, whether you become a judge, you become a lawyer, that's keep aside. But as member of the legal fraternity, it is your duty to protect the Constitution. I remember all of you are not born at that time. Those were days of emergency, 1975-76. I don't recollect the author. He said something very interesting. He said that when the executive illegally arrested a person who was staying in a house in front of me, I did not protest, nobody protested. When they came and arrested neighbors on both sides of my house, nobody protested. And when they arrested me, there was nobody to protest. So therefore, what is important is for every member of the legal fraternity to uphold the constitution and laws. You need not be a judge for that purpose. As a lawyer, you can do that. As a lawyer, you can defend a litigant who is illegally detained in jail. So therefore, this is the most important part of your being member of the legal fraternity, is that your duty is to uphold the constitution and laws.
Yes, sir. Thank you, sir.
Respected sir. Sir, I'm Vaishnavi Kulkarni from K.L.E College, Hubballi. Sir, I'm here. Sorry, sir.
Lights, I'm able to.
Yes.
I'm not able to locate.
I'm Vaishnavi Kulkarni from K.L.E College, Hubballi. I would like to ask a question that what are some common challenges faced by judges in their professional lives?
See, there are many challenges, many. In fact, if you become a judge and you start performing your duties, say for about 10 to 15 days, you can have an unending list of challenges. The first and foremost challenge as a judge you face is that you have to work hard and understand the basic principles of Indian jurisprudence. Knowledge of basic principles, legal principles, is a huge challenge. The second challenge which you face is to maintain your integrity. I'm not talking in terms of integrity in terms of some monetary transaction of money. Honesty and integrity in its common parlance, that is something which is basic, a quality which one must possess if he wants to become a judge, or for that matter, lawyer. I'm talking about judicial integrity. The challenge you face is, as I told your friend, that when you become a judge, you may be having your own personal views about a situation. But the biggest challenge before you is that in a case where you find that the outcome is such, legal outcome of a case will be such that you may not like it personally, then you should have courage to decide in accordance with law. This is one biggest challenge. And the third and most biggest challenge when you become part of judiciary is we have to deal with huge arrears. And every day becomes very challenging because you see 50, 60, 70 litigants coming to your court, and because you don't have time is to how to cope with large number of cases which come before you. So these are broadly 2 or 3 challenges which one has to face. And as there are the challenges, that makes your life more relevant and more wonderful.
Hello, sir. Namaste. I am Anu Patel from final year BLLB student. Sir, I have one question. Sir, why we have to choose judiciary for the purpose of career or for the purpose of development of the nation, sir?
You can answer.
As I stated earlier, if you have to perform some contribution towards nation building, that's the larger picture. Apart from that, even as the issue of bread and butter, I think a 23-year-old becoming a civil judge earns much more than what any law firm will offer. That's one part of livelihood issue. On a larger perspective, it is your sense of duty to make your society a better place to live.
Just continuing with what brother said, it's a unique position. It's a unique position where not only you have reasonable remuneration, reasonable perquisites, but at the same time, you can contribute to the nation. I heard a lecture by a very eminent judge of the Bombay High Court, retired as a Supreme Court judge, as a young lawyer. Somebody asked him that, sir, becoming a judge involves sacrifice. Perhaps in those days, there was a monetary sacrifice involved. Today also it may be to some extent. So he answered by saying that, young man, it may be a sacrifice, but it's a 5-star sacrifice. Because by sacrificing some income, some more income you may get as a lawyer, you get something which is more than that, which cannot be valued in terms of money.
Honorable judges, my name is Ashwin Bhatt. I am first year GK Law College. And with due respect, sir, my first question is, how much ready is judiciary to accept the future reality of artificial intelligence?
I take it that you are very techno-savvy. I've been talking to many experts in AI. I deal with AI Translation Committee and many others. Ultimately, you have to give data to the AI system. That data will be analyzed and it will suggest you some result. Those who are working on that, all of them will tell you that what AI system will express is full of prejudices. My personal view is, you may sound that, I am anti-technology, but my personal view is, judging is such a complicated thing that no machine, no technology can replace the human brain, because it is only the human brain which understands human emotions. So AI is useful. I'll tell you where it is useful. For example, we are using AI technology to translate judgments of the Supreme Court and High Courts into regional languages. We are using AI techniques for classification of cases. Maybe AI techniques, we are trying to use it, for dealing with procedural aspects of judiciary. So AI techniques can be extremely useful, but when it comes to justice delivery, actual justice delivery, that justice delivered by the judges in the court, I don't think beyond a particular limit it will be useful. At highest, I'll give you an example. You must have heard that there are motor accident claims tribunal. If somebody dies as a result of motor accident, the heirs of the deceased are entitled to compensation. Now there is a formula laid down by Supreme Court how to calculate the compensation. For calculating that formula, AI will be extremely useful. But after the AI tool calculates the compensation, again, human mind or human brain as a judge will have to apply your brain and find out whether the exercise done by AI is in terms of the law laid down by the Supreme Court. So while AI is useful, it has its own limitations.
One more question, sir, I do have.
Yes.
Sir, AI will consume lot of law professional jobs in the next decade, like future times. Sir, what kind of the skills and new approaches we need to develop, sir, in order to live and lead life in law profession in the future time?
Answer is very simple. I'll request you to read autobiography of Justice M.C. Chagla Roses in December. He has discussed what qualities a lawyer must possess, what qualities a judge must possess. But if only one thing which is key to success, whether as a judge or as a lawyer, is extreme hard work. This is one profession which requires extreme hard work. And the profession is so beautiful that if you are willing to work hard, if you have right approach, you can overcome all other shortcomings. With hard work, you can succeed in the profession. As Justice Chagla has said, that nothing succeeds like a success in profession of law. He has said that, if you are a doctor, you succeed. You are dealing with only knowledge in medicine. But as a lawyer, you succeed. You'll know several things. You'll know something about technology because we deal with cases under IT Act. You'll know technology of construction of buildings because we deal with construction of building contracts. So nothing succeeds like a success in profession of law. But one single quality which is required, basic quality, is hard work.
Thank you so much.
Just a second, friend. How many of you have used the typewriter? None of you. Maybe one or two. I'm a very senior typist. Now I don't have a typewriter. Whether my job has gone, I have converted myself into a desktop publishing. That's all about the AI. Human brain is required. That's only a machine. What we are feeding is the mind of the human, which is into the AI. Its name itself is artificial. It is not natural. Each one of us have got the DNA to survive. And the Darwin theory comes. Survival of the fittest. Excel the AI. Right.
Good afternoon, sir. My name is Shruti Godke from Raja Lakamgowda Law College, Belgavi. I'm studying in 9th SEM BLLB 5-year course. So my question is, what is the one thing that a person who wants to pursue their career in judiciary must follow, especially the first generation lawyer and also the aspiring women judges?
It's a good question. When you join profession of law as a first lawyer in the family, first generation lawyer, you always feel that those who are second generation lawyers, they have advantageous start in practice. But when it comes to judiciary, that disadvantage is not there. Because now suppose you want to join judiciary as a civil judge, what you require is a very sound knowledge of law. You have to prepare yourself for that examination. You have to prepare yourself for interview. Now, judicial post is such post that I don't think a second generation lawyer will have advantage over the first generation lawyer. So if you aspire to become a judge, don't bother that you are a first generation law student or first generation lawyer. Just concentrate on reading more and more law, understanding the basic concepts of law, and preparing yourself for the examination which is conducted. And then you did not bother about second generation lawyers or third generation lawyers.
Yes, sir.
It's also many a time an advantage that in case you're a second generation lawyer, you come with a baggage of practice of the first generation. But as a newcomer, you can start afresh. And nowadays, it's not as difficult as it was. The quantity of litigation in urban areas and even otherwise is such that you'll bump into somebody who has a legal problem. And that's a normal evolution of society, where the more advanced the society is, the volume of litigation is higher. And you can make a mark much faster, unlike before.
Have you recently followed the IPL auction?
No, sir.
Tendulkar's son was sold for the least price. Rohan Gavaskar is out of the picture. You can decide by yourself.
Yes, sir.
Next, don't have FASHION. You have PASSION.
Thank you, sir. So adding to my question, so what changes would you like to see in the legal system? So the upcoming legal system.
Very broad.
It's a very, very broad question. And we can have, even 2 days are not sufficient to have debate on this. But 2 sentences, I'll try to. My own perception of what should be the biggest change in judiciary. I believe that biggest change in judiciary will happen when all brightest of the students decide to join judiciary. That itself will bring about a great change. Those who consider to be brilliant legal minds all of them decide to join judiciary, that will bring about revolution.
Hi, sir. I'm Vishal Uppun from second year LLB, GK Law College. I have a question regarding secularism. How does judiciary protect and promote secularism in judiciary?
It's as simple as this. See, there is a philosophy known as constitutional philosophy. There are constitutional ideals. There are constitutional ethos. If somebody, now, see, ultimately, before I answer the question, what is your concept of secularism?
How does judiciary protect
No, what is your concept of secularism? Understanding of secularism, what secularism means.
There is no practice of certain religion. Only one religion should be practiced. Every religion has a...
See, firstly, please understand, what is the meaning of secularism? Broadly, I'll tell you. There are many nuances in that all religions are equal. Every person has right to practice religion of his choice. If somebody says that I will not allow other citizen to practice religion of his choice, then ultimately that is encroachment on the fundamental rights. And the constitutional courts are there to enforce the fundamental rights. It's as simple as that. Because our constitution says that every individual has choice of adopting a religion. And nobody can say that you are bad because you belong to a particular religion. And if somebody says that, he is violating the fundamental rights, and therefore courts can always take him to the task.
Respected sir, I am Pallavi Dodmani from GK Law College, and my question is, how important is continuing legal education like post-graduation or special courses helpful for a judicial career?
I will tell you something very interesting. Whether you become a lawyer or a judge, or more particularly judge, your legal education continues every day. Every day you have to be a student of law, because we have hundreds and thousands of laws. So every day you have to adopt the role of a student, and continuing legal education has to continue till you are part of the legal system. As a Supreme Court judge, I will tell you, after going to Supreme Court, I have to deal with cases under those laws which I have not even read. So I have to become a student of law. I have to go to the basics. I have to read all the sections of a statute which I have not dealt with. And as a student, I have to think about that law. I have to analyze that law. So when you are a judge, you have to be a student every day till you limit office.
Thank you, sir.
Last two questions, please.
Good afternoon, sir. I'm Akash from B. Bellad Law College. So my question is, what reforms do you believe are essential to address the pendency of cases in Indian courts, sir?
Answer. I'll supplement it. No, I'll be the last one to answer this.
See, pendency is a legacy. You please understand this. It was not today's. There is a famous saying, new case become old because of the old cases. Right? ಹುಚ್ಚ ಬಿಡೋ ತನಕ ಮದುವೆ ಆಗಲ್ಲ, ಮದುವೆ ಆಗೋ ತನಕ ಹುಚ್ಚ ಬಿಡಲ್ಲ. See, larger concept, ಡಾಕೆಟ್ ಎಕ್ಸ್ಪ್ಲೋಷನ್ ಅಂತ. ಹೆಚ್ಚು ಪ್ರಕರಣಗಳನ್ನ ಬರೋದನ್ನು ನಾವು ತಡೆ ಹಿಡಿದು ಬಿಟ್ರೆ ಅನ್ಯಾಯ ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಂತ. ಡಾಕೆಟ್ ಎಕ್ಸ್ಕ್ಲೂಷನ್ನು ಮೋರ್ ಡೇಂಜರಸ್ ದೆನ್ ಡಾಕೆಟ್ ಎಕ್ಸ್ಪ್ಲೋಷನ್ ಅಂತ. ವಿ ಹ್ಯಾವ್ ವಾಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಜಡ್ಜ್ ಲಿಟಿಗೆಂಟ್ ರೇಷಿಯೋ ಅಕ್ರಾಸ್ ದಿ ಗ್ಲೋಬ್. ಆಸ್ಟ್ರೇಲಿಯಾದಲ್ಲಿ ಸುಮಾರು 869 ಜನಕ್ಕೆ ಒಬ್ಬರು ಜಡ್ಜ್ ಇದ್ದಾರೆ. ರೈಟ್, 869 ಜನಕ್ಕೆ. ಫಿನ್ಲ್ಯಾಂಡಲ್ಲಿ ಅದು ಇನ್ನೂ ಕಡಿಮೆ, 300 ಜನಕ್ಕೊಬ್ಬರು ಜಡ್ಜ್ ಇದ್ದಾರೆ. 140 ಕೋಟಿ ಜನಕ್ಕೆ ನಾವು 1 ಲಕ್ಷ ಜನ ಇದ್ದೀವಿ, ಸಾಕಾ? ಆದರೆ ನಮ್ಮ ರಾಷ್ಟ್ರದಲ್ಲಿ ನಮ್ಮ ಜುಡಿಷರಿ, ಇಂಡಿಯನ್ ಜುಡಿಷರಿ ಆಸ್ ಎ ಹೋಲ್ ಹೇಳಿದ್ರೆ ರಫ್ಲಿ 1 ಲ್ಯಾಕ್ ಜಡ್ಜಸ್ ಇದ್ದೀವಿ ನಾವು. ಅಷ್ಟು ಜನರನ್ನೇ ಇಷ್ಟು ಜನ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀವಿ ಅಂತಂದರೆ ಯಾವ ಸಿಸ್ಟಮ್ ಚೆನ್ನಾಗಿದೆ? ಒಂದು. ಎರಡನೇದು, ಅನ್ವಾಂಟೆಡ್ ಅನ್ಫ್ರಿವಲಸ್ ಫ್ರಿವಲಸ್ ಲಿಟಿಗೇಷನ್ಸ್ ಆರ್ ದೇರ್. ಅನ್ವಾಂಟೆಡ್ ಅಂಡ್ ಫ್ರಿವಲಸ್ ಲಿಟಿಗೇಷನ್ಸ್ ಆರ್ ದೇರ್. ಅದನ್ನು ತೆಗಿಬೇಕು. ಮೂರನೇದು, ದಿ ಬಿಗ್ಗೆಸ್ಟ್ ಚಾಲೆಂಜ್ ಇನ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಇನ್ ಹ್ಯಾಂಡ್ಲಿಂಗ್ ಈಸ್ ಫಾರ್ ಆಲ್ ಅಂಡ್ ಸನ್ಡ್ರಿ ಪೀಪಲ್ ಆರ್ ಕಮಿಂಗ್ ಟು ದಿ ಕೋರ್ಟ್. There is no system in the place. An application is filed which has to be disposed of within 30 days as per the system of the government, what is called Sakala. That is not done. Tomorrow you come to the court, my application is pending, consider as per Sakala. That's their case now. So who is the biggest litigant in our country? It is the system. It is the government. So what is happening is, if the system is in place, ನಿಮ್ಮ ಕೆಲಸ ನೀವು ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ, if you stop at the red signal without jumping it, there is no one traffic violation, no case. Are you doing it? Are you wearing the helmet? Only two of you are going, whether both of you are wearing the helmet. So every day you violate, and such are the people who cannot tolerate with the other systems, other wings of the society, are only finding it as a last resort or inevitable resort to come to the court. Naturally, the pendency will grow. What is happening is, one is there is a total variation from the judge population ratio. Second is unwanted and frivolous litigation. ಇದನ್ನ ಪ್ರತಿಯೊಬ್ಬರು ಪ್ರಜ್ಞಾವಂತರಾದರೆ ಅಲ್ಲಿಗೆ ಅರ್ಧ ಕೆಲಸ ಮುಗಿಯುತ್ತೆ, ಪೆಂಡೆನ್ಸಿ ತಾನಾಗೆ ಕಡಿಮೆ ಆಗುತ್ತೆ. ಮೂರನೇದು, ರೂಲ್ ಆಫ್ ಲಾ ಏನು ಅಂತಂದರೆ, 180 ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಸಿಗ್ನಲ್ ಇದೆ ಕಿತ್ತೂರು ರಾಣಿ ಚೆನ್ನಮ್ಮದಲ್ಲಿ, ಎದುರುಗಡೆಯಿಂದ ಯಾರೂ ಬರ್ತಿಲ್ಲ ಅಂತಂದ್ಬಿಟ್ಟು ನೀವು ವೈಲೇಟ್ ಮಾಡೋ ಹಾಗಿಲ್ಲ. 180 ಸೆಕೆಂಡ್ ಕಾದು ಗ್ರೀನ್ ಬಂದಾಗ ಹೋಗಬೇಕು. ದಟ್ ಈಸ್ ವಾಟ್ ಈಸ್ ರಿಕ್ವೈರ್ಡ್. ಅದನ್ನು ಫಾಲೋ ಮಾಡದೇ ಇದ್ದಾಗ ನೀವು ಕಂಟೆಣ್ಣೆ ಹಾಕಿದ ಮೈಸೂರು ಪಾಕ್ ತಿಂದರೆ ಗಂಟ್ಲು ನೋವು ಗ್ಯಾರಂಟಿ.
See, as a law student, you must apply your mind, and everything is now in public domain. In 2002, there was an order passed by Supreme Court. As brother said, Supreme Court discussed the concept of judge to population ratio. Ideally, how many judges should be there for population of for 10 lakhs, population of 10 lakhs. The Supreme Court, as brother said, considered the judge to population ratio in developed countries. Somewhere it was more than 100, 113, 70, 75. What that order of the Supreme Court expects is that within 5 to 10 years, India should achieve just to population ratio of 50 per million, 50 for 10 lakhs. So that object should have been achieved by 2007 or at the most by 2012. Today we are struggling at 22 or 23. And during the span of 25 years, the population has multiplied, the litigation has multiplied. And one more example, which I'll give, goes to the root of the matter. When I was the Chief Justice here, in one particular year, normally all high courts conduct recruitment process once in a year. 1 year, we conducted 3 processes of appointing civil judges. We could not get sufficient number of candidates in all the 3 processes. Now, if you are not going to get sufficient numbers to fill in the existing post, we are talking about something which is high, 50, just to a population ratio of 50. So bar members are contributed. And one more thing, please remember this, that it has sad reflection on rule of law also. If rule of law is implemented in our society, the occasion to go to the court will not arise. I always say this, that, we think about religion, we fight for our religious right. Unless rule of law becomes part of culture of our society, the cases in courts will continue. As citizens, we don't have control over the executive. I'll give a small example which brother gave. Simple example. Somebody who after working for 30 years acquires a property, gets property under a sale deed, registered sale deed. Law requires that revenue authority should enter his name in the revenue record on the basis of sale deed. But that doesn't happen. The poor person is required to approach the writ court. So the implementation of rule of law the status of our society, tendency to abide by a law, these are all the factors which contribute in courts getting flooded. So this is one question which is very difficult to answer.
Thank you, sir.
So shall we close it or?
Still, last question.
All it one question you can.
Last question.
Yes. Very good morning. Very good afternoon, sir. I would like to ask, how has the role of judges changed with the advent of technology and digitalization, sir? I am from GK Law College, sir.
Role as such has not undergone change. There is a positive side and negative side also. See, one thing you must remember, that use of technology adds to the ease of doing business. For example, I want to deliver a judgment on one particular point. Earlier, about 25 years back, I was required to physically read the commentaries, find out which are the judgments delivered by various high courts and supreme courts in foreign countries, then again physically pull out the law reports. Today, I can sit with my iPad or even my mobile. I get access to judgments delivered by not only Indian courts, but all over the world. So that is ease of doing business. Secondly, as brother said, technology has improved access to justice. Today we see in Supreme Court also, yesterday somebody sitting in a very remote place in Tamil Nadu, 13% addressed us. 5 years back it was not possible. So access to justice is improved, because if you are a lawyer, if you start practicing in Hubli, you can make e-filing of the case in High Court now. Or you can do e-filing in the Bombay High Court also. But you must remember one thing. Technology is certainly useful, but use of technology itself is not sufficient to improve quality of justice rendered by our courts. For improving the quality of justice, something more is required.
Thank you, sir.
As we draw towards the conclusion of this memorable event, it's time to express our gratitude. To do the honors, I invite Dr. Dhyaneshwar P. Chowri, Principal, GK Law College, Hubballi, to deliver the oath of thanks.
Respected Chief Guest of today's function, Honorable Mr. Justice Abhay Srinivas Oak, Judge, Supreme Court of India. Guest of Honor, Honorable Mr. Justice Siddhappa Sunildat Yadov, Judge, High Court of Karnataka. Another guest of honor, Justice V. Shananda, Judge, High Court of Karnataka. President of today's program, Shri Jayanand M. Munwadi, Director, K.L.E Society, Belgavi. Professor Dr. J. M. Mallikarjunaiah, Principal, K.L.E Society's Law College, Bengaluru. Other judicial officer, respected members from K.L.E Board of Management, respected members from Hubli and the Harvard Bar Association, other dignitaries of the dais, faculty members, press and media, participants, and my dear students, a very good afternoon to all of you. Yes, it was a wonderful and very informative deliberations from all the justices. All of you must remember that a career in judiciary is one of the most respected profession, offering an opportunity to contribute meaningfully to society. It comes with a sense of responsibility, pride, and honor in upholding justice and fairness. Choosing a career in judiciary is not just about achieving personal success. It is about serving society, strengthening democracy, and ensuring justice for all. It is a noble calling that combines intellectual challenge with an opportunity to make a lasting impact on people's lives and legal framework of the nation. It's my privilege and honor to deliver vote of thanks at this enriching career in judiciary program. We are extremely fortunate to have Honorable Mr. Justice Abhay Srinivas Oak, Judge, Supreme Court of India, as the chief guest to this program, who despite his numerous and
rather tight schedule, has found time to grace this occasion and to inspire us with his profound insights into the judiciary as career. Your Lordship, your words have not only enlightened us about the opportunities, but also highlighted the responsibilities and dedication required in this noble profession. I, on behalf of K.L.E Society, K.L.E Law Academy, GK Law College, and behalf of all, extend my first and foremost gratitude to our Honorable Mr. Justice Abhay Srinivas Oak, Judge Supreme Court of India, for delivering a wonderful lecture on the very prominent topic, career in judiciary. Thank you very much, sir. The guest of honor of the today's program, Honorable Mr. Justice Siddhappa Sunil Dutt Yadav, Judge High Court of Karnataka, one of the prominent personality whose insightful address has added an extra part to this event and made the event more special. Your Lordship, your valuable expertise and experiences has provided comprehensive understanding of the field, inspiring many to consider the judiciary as a career path. I, on behalf of all, extend my heartfelt gratitude to Honorable Mr. Justice Siddhappa Sunil Dutt Yadav, Judge High Court of Karnataka. Thank you very much, sir. My deepest gratitude to another well-known guest of honor, Honorable Mr. Justice V. Srishanand, Judge High Court of Karnataka, for taking time from his busy schedule and giving a new perspective to the given topic, which inspire our students a long way in their future journey. On behalf of all, I would like to extend my special thanks to you, sir. Thank you very much, sir. We are fortunate to have another great personality amidst us, the president of the program, Shri Jayanand M. Munwadi, Director, K.L.E Society, Belgavi, who has not only extended tremendous support and cooperation in organizing this event, but also personally involved to make this event happen systematically and meaningfully. On behalf of all, I would like to extend special thanks to you, sir. Thank you, sir. The architect of this program, Professor Dr. J. M. Mallikarjuniya, Principal, K.L.E Law College, Bengaluru, who is working from last more than 6 months on this event with a pious object to encourage and motivate to the students community of this region through the honorable judges of high courts and supreme courts to take judiciary as a career. Sir, your meticulous planning and seamless execution have ensured that every detail was taken care of, providing a valuable learning platform for all the attendees. Thank you, sir. I would like to thank all the judicial officers from Hubli and the Harvard courts who are present on this occasion. My heartfelt thanks to the principal of other K.L.E law colleges, Sir Gitte sir, Jyoti Hiremat madam, Karan Solapure, Jai Hanuman sir, for gracing this occasion. I would like to thank the members from press and media for giving wide coverage to this event. I would like to thank all the students, participants from various law colleges for their active involvement. Your curiosity and enthusiasm reflect the potential of your future judicial professionals. I thanks to all the advocates who are present on this auspicious occasion. Lastly, let us not forget the unseen pillars of a college, my colleagues, all my students, our technical team, supporting staff, and everyone behind the scene who ensured this program runs smoothly. Thank you all. Above all, I am sincerely grateful to all the members of local governing body, executive body for all the K.L.E law colleges, Belgavi, members of board of management, K.L.E Society, Belgavi, especially Dr. Prabhakar Koriji, Honorable Chairman, K.L.E Society, Belgavi, for extending unwavering support to organize this event. Once again, I thank each one of you for your presence and contribution. Let us take the inspiration and knowledge gained today and channel it into our perspective journeys towards justice and service to the society. Thank you, one and all. Thank you, sir.
I request everyone to rise for national anthem. Jana Gana Mana Adhyaya नायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ मागे गाहे तव जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे. I request everyone to be standing till the judges proceed. Sir, our books. Heads. Lunch arrangement to all the students has been organized in K.L.E College campus. Please proceed to the campus.